Please give a round of applause to welcome BIJU NAIR, and who will be talking about open source legal issues. Okay. Over to you, BIJU.
Thank you. So good afternoon. My name is BIJU NAIR. I am a lawyer, and today we will try to cover some of the issues around open source, which we have seen in various forms and in various jurisdictions. So I will today talk about a global perspective, not a jurisdictional perspective, a global perspective. So what I talk today is not a legal advice. So I represent two communities. One is Open Invention Network, and I also am a founder of a law firm called Legalitech. So what we talk today is not a legal advice for any of you. So some of the issues we will talk today is about copyright, patents, and trademark. So any of you have faced any of these issues? Anybody who has faced any of these issues? Okay, I see a good number of hands. So why do we, when we face these issues, there is a lot of consequence of that. There is financial consequences. There is, community issues which we face. So compliance assurance, risk mitigation, reputational protection, financial cost, and community trust. So let's say you have been sued. You are a project or you are a company which has been sued. If you are a listed company, your shares are affected. If you are a project, the trust and the non-compliance creates a lot of problems for you. So it is always better to do things before you ship your product, whether you are a company, you are a project. So what I wrote about is also called something called check before you ship software. Because unless you don't check it from a legal perspective, things can be problematic once you ship it. Otherwise, there could be legal risk. You could be sued by various entities. You could be sued by a competitor. You could be sued by a copyright troll. You could be sued by a patent troll. So there are various problems you could be facing. So it's always better to understand this risk, and you can do risk mitigation. So it could be compliance. It could be various other things which you can do. So now let's look into copyright infringement. You would have seen various entities, various projects facing copyright issues. So typically, irrespective of the jurisdiction you are in, whether you are in US, you are in Thailand, or anywhere, the law protects the copyright. So when your code is created, there is a copyright which is granted. So in some jurisdictions, there is a registration of copyright required, but most of the jurisdictions, you don't require a copyright registration. So if somebody is using the code you have created without your permission, that is a copyright infringement in most of the jurisdictions. So you have to, when you are using any code of anybody, just see what is the code, who owns it, whether it is owned by a foundation like Apache Foundation, what is your obligation of usage, whether you have to make an attribution or you have to give a notice that this is a code from Apache Foundation. So you would find generally a C and a circle, like at the bottom I have put it there. So that means that there is a copyright on this content which has been created by me. And who owns it? It is owned by Legalitech. So that's where you understand that, okay, somebody has created this, he or she owns it, or this foundation or this company owns it. You have to take permission. And what are the other obligations you have? All those will be there in the copyright notice. So that's what we call it as the copyright notice. Now, let's also look into various licenses. So what are the obligations of yours when you're using that code, piece of code, is in the form of the licenses. So sometimes in a GPL3, it will be a patent grant back obligation. So if you can't fulfill those obligations, which is there in the license, please don't use those piece of code. If you can comply with the license obligations, please use it. Otherwise, you will be in great danger of you being sued, or in some scenarios, you are using this code for building for your clients. So they could be sued. Let's look at it from a automobile manufacturer. There are various vendors for that automobile manufacturer. So if one vendor in the whole supply chain is non-compliant, ultimately it will be the automobile company which could be sued in this scenario, because I would not know who is the vendor. But I only know that this car has been manufactured by this automobile manufacturer. So it is very important that, especially in the global supply chain, that you are compliant at every level. So it becomes really scary, because how do you make sure that everybody in the supply chain is compliant? So I think you had a question, how do you choose my license? So there are various factors when you choose a license, because there are different types of licenses. There is copyleft licenses, permissive licenses. So it depends on your use case scenario, because it might be used internally in your company, then things are easy. But if you are going to make it as a product, part of your product or part of your offerings, then you have to be careful. Like, that's why I gave the example of GPL3. There is a patent grant back clause. So you are a company, you can't use a GPL3, because especially if you are selling it externally, it's not being used, consumed internally, then there is a scenario which has to be looked into. So there are various interests you have to look into. What is the scenario? Whether it is being used in the servers or it is used by a SaaS entity. What is the objective? What is the license? What is the obligations? Can you meet those obligations? If you can't meet those obligations, please don't use it. So all these criteria are very important. Whether the license also is compatible with other codes or licenses you are using. Let's say there is a GPL2 and there is LGPL. There is an incompatibility in the obligations. So in that scenario, you can't use it. So please look into all these things when you choose a license. That determines what license you should choose. Then many scenarios you would get a copyright infringement notice. Unknowingly, unintentionally, one of your team members in your project or your company used a code which belongs to somebody else. So if you get a copyright notice, infringement notice, look at who sent that. Whether it was sent by a copyright troll, it was sent by an open source foundation, it was sent by a company. If it was sent by a company, look at what was the background to that. Gather all your facts, because it's very important whether there is an actual infringement done by you. If there is no actual infringement done by you, things are different. If there is an actual infringement done by you, then what you should do is look at what is the history of the background of the company or the entity which has sent it. So if there's entities like a copyright troll, so we have seen this scenario in Germany where a copyright troll called McCarty sued. He was part of the same community, but his objective was to make money. There are also enforcements done by entities like Software Freedom Law Center or Free Software Foundation. In those scenarios, the objective is to ensure compliance. It is not money. So you should gather your facts. You should check whether there is actual copyright infringement. What is the extent of damage you have done? What is the extent of infringement you have done? If it is unintentional infringement, in certain cases you have exceptions under the copyright law. It's a fair use exception. So most of the copyright laws have a fair use exception. So let's say you have not used it for a commercial purpose. That could, in certain jurisdictions, you could come under a fair use exception. So it depends on each of those scenarios. So you should be mindful of all these things. So this is the famous copyright troll I was talking to you about. where his objective was to make money. Now let's come to the other issue of patents. So you would have also seen that many entities, the open source foundations, like Genome Foundation was sued by a patent troll called as Rothschild in the year 2019. So what Rothschild expected was that Genome Foundation will pay them money. And Genome Foundation, being an open source foundation, doesn't have money. So what they did was, they joined a community called as Open Invention Network. In fact, I also represent Open Invention Network. Open Invention Network was created to ensure that there is no patent tension in the whole Linux and open source ecosystem. So this is a 22, 23-year-old community, and anybody, you are a project, you are a company, you are anybody in the ecosystem, you can join the community free of cost. There is no commercials to join the community. You join through an e-license where you take a pledge that you will not assert your Linux and open source patents if you have one. We have many community members who don't have any patents. And you get a reciprocal pledge from the community members. So it's a reciprocal pledge, to put it simply, that you will not assert your Linux and open source patents against the community members, and the community members on the same level gives you a reciprocal pledge that they will also not assert. The objective is to ensure that there is no patent tension. So let's understand who creates a patent tension. It could be an operating entity which could sue other companies who has patents, or it could be done by non-practicing entities. They are called NPEs, or patent assertion entities. So their objective is they don't have any products and services. They just buy patents from innovators, and then they sue companies big and small, or open source projects, everybody. So these are the two creators of patent tension in the whole ecosystem, open source ecosystem. So what we do at Open Invention Network is that in case you have been asserted by an operating entity, we give you patents to retaliate. In the past, we have seen this in two scenarios. The other case is where you have been sued by a patent troll. So in case of a patent troll, they don't have any products and services. So you can't use the patents in this scenario. So what we do is, we give you prior art. With the prior art, you can go and invalidate the patent of the patent troll. So for any patent to be granted, there has to be novelty. Once you can show that there is a prior art, the novelty is extinguished. So you can challenge the patentability of the patent owner itself, and with that invalidation, you can invalidate the patent claim of the patent troll. So in case of Genome Foundation case also, we did the same. Once Genome Foundation was part of the community, we gave them prior art. With the prior art, they went for invalidation. They raised crowdfunding money. And with the crowdfunding money, they went and invalidated the patent troll. So in this scenario, even a foundation was protected. Typically, patent litigation is expensive. So this is one way of mitigating patent troll. The other way is also, we also have tied up with unified patents, where unified patents on behalf of the community also goes and litigates against the patent trolls and settle matters. The other case is of trademark issues, which typically projects and companies face. When they start their project, they don't take seriously their trademark issues. So let's say I started a project XYZ. So I have to, before I use any word, I have to look into whether there is a similar word being used by any project across the globe, because it creates confusion. So it's very important that before you use any name, check whether anybody else is using it in the same domain. Otherwise, there will be a lot of confusion which can be created. So it's always better to look for this and ensure that, and you also for register. Unlike copyright, trademark registration is compulsory across the globe. So it's better to register for the trademark for your project or your thing what you're doing. most of the communities you would have seen, foundations you would have seen, there is a trademark policy. Who can use it? Who can use my trademark? In what format it can be done? And how it can be used. So you should also, every foundation should have a trademark policy and guidelines so that people don't misuse your name. Like, for example, I use the name of Apache Foundation intentionally and put malware into that. People, when they use that piece of code, they will think that, okay, this has come from Apache Foundation, but it was not from there. So that's a misuse of the Apache's trademark policy. So it's very important that you create a trademark policy for your project and make sure that nobody misuses it. I think I'm short of time, so I also wanted to talk about notices. Once you receive any notices, how do you handle it? How do you handle cease and desist notices? You can seek community advice. You can do a background check, assess the claims. And these are some of the global projects you can look at. So OpenChain is a Linux Foundation project for open source compliance. Whether you're a project, you're a company, you can do a self-assessment of your compliance. So there's some great work happening there. Then there is OpenSSF for security requirements. Because in today's time, if you have a vulnerability breach, there is also data protection laws which can affect you. So it's very important that you make sure that your project or your work there is no data breach because of that. So consequences, I don't have to tell you. You all know that well. Any questions? I don't think we have time for questions, but don't worry, I'm available in the premises.
First, let me check. Is our next speaker here, Nitish? Okay.
He's there.
Sorry, no time for questions.
Yeah, but I'm here. Please feel free to.
Yes, and the slides are very comprehensive, so I believe that you can get a copy of the slides from the repository, wherever that might be.
Available at this email address and the phone number. So anybody, anything, please feel free to reach out to me.
Oh yes, on the page with the session information.
Yes.
The slide, there'll be a link to the slides there.
Thank you.
So thank you very much.